Hi everyone, good evening. So today we have come here again like once a month that we come here for another Adda session. Today's Adda session is going to be from Yug Pratik, who passed out of Ramakrishna Mission Vidyapeeth in 2015. And the topic of today's Adda session is going to be evolution, structure, and importance of law in India. So, giving a brief introduction about the speaker and the moderator today is because, today's speaker is very special and near and dear to me because when he joined Vidyapit in 2010, me and him shared the same dham, Vivekanand Dham. And the moderator over here, when we joined Vidyapit in 2009, we shared the same dham also, Subodhanand Dham. So both the moderator and the speaker are very near and dear to my heart. I know both of them. I have seen them change from being a 10-year, 11-year kid to what they are today. So over here, we are going to hear from Advocate Yug Pratik. Actually, I'm used to calling him Yug, but now I have to give him the due respect. Advocate Yug Pratik about the evolution and importance of law in India. So in these days at Vidyapit, I still remember Yug was not a very law-abiding student. He was not a student who would go by the rules laid out by Mohan Maharaj. He was something who would like to have his studies. He was always good at his sports. He was good at everything. But one thing that I remember is that he had a bit of an issue with following the rules. I think that's why today, when I see him as an advocate, I feel like the irony of life that somebody who used to live life in Vidyapit at his own terms, in his own flow, is today preaching and informing us about the importance of law and following the rules in the country. Over to you, Aditya, for introducing you to us of how he is these days.
Thank you, Karthikeya, for the wonderful introduction. We know you as Karthik and previously as Satyanand Podar, but then it's all right. So here we are. So it's a proud privilege to be amongst the fraternity back again, although through a virtual mode. And the second privilege is because I have the honor of introducing Yug Pratik, who is a very fond junior brother, now a colleague. Here in Delhi, we are practicing together. We work on matters together. We frequently meet and mostly on alternate weekends, we try to catch up. Yug Pratik is a Delhi-based advocate practicing before courts and tribunals across India. If we go by a formal introduction, he specializes in corporate and commercial litigation, real estate, uh, arbitration, and insolvency law. He is also an accredited arbitrator with the Indian Institute of Arbitration and Mediation. Additionally, he also holds a BA LLB honors degree from ICFI University, Dehradun. He also did his LLM from Nalsar, Hyderabad. Over the years, he has represented leading clients, including the JP Group, Reliance, SDFC Bank, NHIA, Jet Airways, Career Launcher, and handling all sorts of complex commercial and regulatory matters across diverse sectors. So beyond the courtroom, Yug also enjoys, and as I'm told, and I have seen his reels and interests, he enjoys traveling a lot, especially to the mountains. He is a frequent visitor. Whenever he gets time, he tries to steal trip there. So he explores various destinations and playing sports. Yeah, that is also, I don't know how much is he able to pursue it right now, especially in litigation. But in this Praktani Adda, he will be sharing an engaging overview of the evolution, structure, and importance of India's legal system. And he would be offering practical insights into how the law shapes our rights, responsibilities, business, and everyday lives. So I welcome you, Pratik, once again. And I'm told that there will be a PPT that he will be presenting on this very issue. So over to you, Yug.
Thank you so much. So before I start with the session, before I delve into the technicalities of the topic, I would love to extend my heartfelt gratitude to each and everyone present here, to the Praktani family, And yes, to Ritesh Da for believing in me. He was the one who reached out to me as I can remember in 2024. And it's and yeah, I would like to share my thanks to extend my thanks to him for believing in me. Coming to Kartike Bhaiya and Aditya Bhaiya, like they are my direct seniors from Vidyapeeth days. And Kartike Bhaiya especially, we shared 2 times, we shared the same dham together. And as evident from his welcoming note, it is very much clear that he still remembers a lot about me, and for that I am deeply indebted. I'm very grateful to him that he has remembered me throughout this year. Still, after having lost touch for more than 10 years or so. And yes, to Aditya Bhaiya, we meet frequently. And uh, he has still he has been a very adorable senior. He has been like a big brother. And uh, right from Vidyapeeth days to now in the legal fraternity, he has been a guiding figure. And whenever I whenever I struck in any technicality, any if there is any loophole on my part, he's there to correct me. He's there to guide me. And yes, well, as Kartikeya said, I was not that. He very rightly pointed out, I was not that rule-abiding citizen. I was always someone who was inclined to go against the rules. Uh, Mohan Maharaj was vexed by me. Krishanu Maharaj was vexed by me. But yes, that was. But over the time, and especially with due to the upbringing that I got in Ramakrishna Mission Vidyapeeth in the 5 years, it was only Ramakrishna Mission Vidyapeeth which made me believe in the rules, and which made me understand that to grow as a perfect human being, as a sensible person who is duty bound towards the society and the nation, you need to abide by the rules. And yes, among others, this is something which has been the motivating factors to for me to pursue the law. So again, thank you very much for having me on board. And with this, I will be starting the today's session, which is titled as India's legal system evolution, structure, and importance. Uh, I hope the screen is visible to the participants over here.
Not yet, I guess.
You have to share again, huh?
Okay, I will do it. Hope it's visible now. Thank you.
Yes. But you have to focus on the slide. I can see myself on your screen. So
Sure, I will minimize the window. I hope it's clear now.
yeah.
Okay. So, as the title goes, India's legal system evolution, structure, and importance. So, chronologically, serially, I will be touching upon the 3 separate aspects that have been highlighted in the title. Well, talking about the evolution part, evolution, a general notion as a layman's understanding goes, in India's legal system is believed to have evolved since the nation's independence in 1947. But as a law student and as a practitioner of law, I have come to the understanding of of the beautiful evolution of law in our country. It is similar to a journey, under like everyone of us undertake a journey from one age to another, from one place to another, from home to office, and back from office to home. Law the Similar has been the journey of the legal system in India. And which which evolved as early as the pre-Vedic age, which as you can see pointed out in the PPT as from ancient dharma to 1.4 billion person democracy, which is the current stage of India right now, a journey through 3,000 years of law. So this is not something which has this is not some development which has taken place within in the span of 10 to 20 years. The journey has been as long as 3,000 years, and within that 3,000 years there have been multiple sources from which which has contributed significantly to the evolution of law in India. And taking well, I will like to start from the very ancient period, and within that I would like to point out the pre-Vedic age, that is during the Harappa civilization, Indus Valley civilization age, when interestingly when as early as during the before around not 3,000 years, it was 5,000 years back, when there were when the laws when the people when the society was governed by democracy, and there and the structure was democratic, and there was a head priest, and the concept was of dharma was there. Dharma, which in simple sense there has it is dharma, the concept of dharma is in itself very is dynamic in nature, but in simple terms, if you like, in a simple one liner, it can be said righteousness and duty, and where to do what is right to and abstain from doing what is not right. And right and what is right and what is not right was the authority was vested in the panel of the priests that during that period, who used to interpret the text available during that time, to instruct and to impart knowledge to the citizen as to what is right and what is not right. Then our then after that we have the Vedic age, when the four principal Vedas, the first one being the Rig Vedas, then Yajur Veda, then Sam Veda, and then Athar Veda. These four literatures were the guiding factors of the society, of each and every individual, as to how life should be, as and what are the rules, to be followed to have a better lifestyle, and to have a better society. So, and after that we have the post Vedic age, when we can see the development of texts like Manu Smriti, which nowadays is a little bit controversial, but yes, although not available and not interpreted in the right sense, but yes, during that time, and owing to the structure of the society at that time, Manu Smriti was one of the guiding factors and one of the principal law books of that age, which contributed significantly to the development of today's legal system. And another principal literature that I would like to quote over here, apart from these Manu Smriti and the Dharma Shastra, the Puranas, and the are the ones are the couple of literatures drafted by Chanakya, one of the best legal minds that has been produced by our nation. Those are Chanakya Niti and Arthashastra. Arthashastra majorly touches upon the economic aspects, and but Chanakya Niti, it covers a very broad spectrum as to structure of the political structure, the structure of the society, and how governance should take place, who is an ideal king, who are the ideal citizens, what are the rights of the citizens, what are the duties of the citizens towards the state, and how state and the king is bound to protect the citizens. Then then we have the medieval period, that is somewhere in the late to 12th century, after the Battle of Tarain, from the advent of Delhi Sultanate, when Qutbuddin Aibak took over the throne of Delhi, there was an influx of Islamic rule and Islamic literature and the Islamic rules and regulation in the country. From the advent of the Delhi Sultanate, covering the Mughal period as well, and till the advent of the British influx in India, we there were evidences of Sharia influenced administration for criminal and civil matters among Muslims. What we can infer from here is that at that time, the law was divided into two broad categories. Those were criminal and civil. So I will be discussing these two broad categories in detail in the slides to come. Right now, what I will be briefly highlighting as the criminal laws were something that were designed to curb and to check some the offenses which were considered as derogatory to the society as well as disturbing to the public harmony. After that, coming to the civil matters were something which were majorly related to the transaction between the two individuals that were essentially private in nature. As we in strict legal terms, they were like so they were like majorly governed. They were majorly designed as to govern the transactions, the agreements that take place between two individuals where in various courses of life. And during that time, Hindu personal laws, at that time also our nation was majorly had the major population of the people practicing the Sanatan way of life, following the Hindu Dharma. So Hindu personal laws continued under local customs and creating a genuinely pluralistic legal culture centuries before modern pluralism. So essentially, that was a blend. That was something where there was nothing homogeneous. There was a blend of Muslim personal laws, their own rules and regulations that was carried by them and brought by them into the nation from their own land. Today's Turkey and Afghanistan and all, and whatever was indigenous to the nation continued for the people practicing those. Then we had like a 360-degree turnover when with the advent of the British, and how gradually they actually reshaped, and how gradually they reshaped the legal system of the nation. So British were, at that time, what they observed is that to rule over the country for a longer period, they should design something which is kind of a unified rules and regulation, which is kind of a unified system, which is applicable on everyone regardless of their race, caste, and community, religion, and which is equally applicable upon everyone, be it civil or criminal, be it related to the rights of the citizen or the duty of or their duty towards the state. So in the course of in aiming such development of a unified legal system in India, the first major development that took place was in the year 1726, when the British established the mayor courts. Mayor courts, initially they were established in the presidency towns, which were three in number. Which Madras, that is today's Tamil Nadu. Then we have Bombay, which is today's Maharashtra and Gujarat, and then another one is the Calcutta, which comprises of the region of today's Bihar, Bengal, Jharkhand, as well as some parts of Odisha. After that, they had the Regulating Act, and the milestone that was achieved by the British, major milestone, was in the year 1860. That is the year when they drafted the Indian Penal Code, which is now replaced by Bharatiya Nyaya Samhita in the year 2023. So the the object behind the incorporation of Indian Penal Code was to check and equally implement the laws relating to the offences of criminal nature, and that was something that was kind of establishing the supremacy of the British over the indigenous Indian people, and as well as to aim as well as to bring their object of unified legal system all across the Indian subcontinent to life. Then we have then after around 70 years or so, we there was a federal court established, which gradually developed as the today's Supreme Court of India. Before that, which has not been highlighted in this presentation, is the establishment of the high courts, which were again established in the presidency towns in today's Mumbai, then Calcutta, and in Madras. And with and as per the changing needs of the society, as well as the developments taking place, as well as with the ideological shift that took place in the country. It was in the year 2023 when ITC was replaced by Bharatiya Nyaya Samhita. So this is something which was brought, which continued till 2023, and which was brought in place in the in the domain of Indian legal system even before the enactment of the Constitution of India, which which is the principal law book governing each and every corners of law in India. Now coming to this supreme law book, which is above everything, and which is the guardian as well as which is the boss, and that is the Constitution of India, which was adopted on 26th of January 1950, as known to everyone. And interestingly, it is the world's longest written constitution, and with 395 articles, 12 schedules, and 105 amendments. Not 105 amendments, there have been more amendments, which it is not updated over here. And the interesting aspect of our constitution, that is Constitution of India, is that it is a beautiful blend of the laws of, that has been borrowed from the all corners of the globe. We we have taken inspiration from the US. We have borrowed significantly from the UK. We have taken from Ireland, from Canada, from USA. We have borrowed the principle of judicial review. Judicial review is something that courts are the guardians of the Constitution. Whenever anything happens in the nation, be it any law enacted, be it any action of the executive, be it any action taken by the bureaucracy, if it is contrary to the Constitution of India, the courts have the power to struck it down. And then we have the parliamentary system of government. The structure, as known to everyone, we have the Lok Sabha and Rajya Sabha in the national capital of Delhi, and we have the Vidhan Sabha in the state capitals. Then we have municipal bodies as well as local government, and another subordinate system which has been designed post independence is the Panchayati Raj system. So there has been an hierarchy, and this system for which has for the with the object of good governance has been borrowed from the United Kingdom. Then we have the directive principles of state policy, which majorly highlights our duties as citizens towards the nation. Uh, which in its it ranges from Article 36 to Article 51 of the Constitution of India, and and uh, in this within this domain, there are a range of duties that need to be adhered to by the citizens of India. And some of them are like respecting the national flag, then the legal aid, then then uh, then treating every person as equal in employment, and preserving the nature, preserving the fun and natural landscape of the nation. And then we have the federal structure. Federal structure is something where which is basically there is a break, there there is no the laws made by the union, that is the parliament, that is which sits in the national capital of Delhi, are not rigid upon each and every state, since each and every state in India have their own landscape, have their own way, have their own lifestyle, distinct customary practices, distinct distinct way of life. So what the Indian Constitution has done, it has given a fair amount of autonomy to each and every state to govern and to make laws and to regulate and to enforce the same within their territory, to depending upon the needs and circumstances of each and every individual state. uh, then in this slide, as you can see the chart, this is how the Indian courts uh, are structured, are designed for providing legal services in the nation. For and at Supreme Court sits at the top. It is the supreme body which governs the overall judicial system of the nation. After that, we have high courts, which are 25 in number as of now. And in these high courts are the apex courts in the individual states. Like you can see, for Delhi, there is Delhi High Court, which is the apex body in the region of Delhi. For Bihar, there is Patna High Court. For Calcutta, there is Calcutta High Court. For Bombay High Court, and so on. And now coming to the states, have now states have a fairly large territory, not just to share the responsibility, and for the efficient disposal of uh, dispersal of remedies, and for efficient disposal of cases. Separate courts have been set up in each and every district of India. Those are district courts. And another in each and every district, the design of each and every district in India, again they are divided into various subdivisions. Now we have subdivisional courts as well, for the efficient or for the timely disposal of the cases in those regions. Now, what I had highlighted earlier, I will be discussing in detail over here, are the major branches of Indian law. So basically, the four broad categories that I have highlighted here. Obviously, a student of law would be studying way more classification that I have highlighted over here. But these are the four major sections which covers almost each and every legislation that has been enacted in India, and which governs the legal system. So basically, the first one is the criminal law. Criminal law is something which came with the advent of the Indian Penal Code, and today the principal legislation that is the torchbearer of criminal law in India is the Bharatiya Nyaya Sanhita. This is again a substantive law. Another concept that I would like to touch upon over here is the concept of substantive law and procedural law. Substantive laws are basically something which lays down the rights of the citizens, lays down the punishments, lays down the penalties. Basically, it is what needs to be done is contained in the substantive law. Then we have the procedural law. It basically addresses how it needs to be done, as how, like the functioning of the courts. Bharatiya Nyaya Sanhita, suppose I would like to take the example of the offense of murder, which now the which in the earlier Indian Penal Code, it was an offense punishable with life imprisonment or capital punishment, which is hanging till death, uh, depending upon the grievousness of the offense. Now it is something which is contained in the Indian Penal Code, that okay, the offense, there is an offense of murder. Whoever commits murder is to be, if it is established beyond reasonable doubt in the court of law, then that person will be punishable with imprisonment. But the whole procedure, right from the registering of the FIR to the disposal of the case, there in between that there will be inquiry by the magistrates, then there will be the trials, then there will be the evidence part, where both the parties, the defense as well, the prosecution as well as the defense, will be bringing their evidence and witnesses to support their contentions before the court. So how it needs to be done is majorly governed by the procedural laws. So, in a crux, there is a simple one-liner that one needs to remember: procedural laws is equivalent to how it needs to be done, and substantive law is equivalent to what needs to be done. And then we have the civil law. Civil law is basically, as you can see, it covers disputes related to property, contracts, family disputes, torts. Like contracts, we can see contract is something like we as a layman don't notice, but we enter into contract each and every time. Even when I was invited to address this Praktani Adda, and I accepted that offer, and I'm here, so there is a contract between the Praktani Adda and myself, that I will be here to address. That this is like, and if we carry in a more simple understanding, where like as every one of us, almost every day, go to some shop to purchase something. Say we go to some stationery to buy a pen. So where there is a contract which is entered into the by the shopkeeper and myself as the customer, as soon as I buy a pen. There in that contract, there is a promise, there is a promise. Now consideration is something like, he gave me pen, and for that I paid him, suppose, 20 rupees. And this is something which is which is in legal terms uh, uh, referred to as consideration. Then we have the agreement is something which is any transaction taking place between the parties. If there is a consideration, if there is it is carried with, if it comes with consideration, then it is an agreement. Then moving up the stage, there is the concept of contract is something, all agreements which are enforceable by law. Now law is something like contract. Agreement can be anything. Agreement can be legal or illegal, but if it is legal, then only it is a contract. Like if anybody, someone who is engaged in the smuggling of arms from cross-border nations. Now he contacted the arms dealer, he placed the orders. Now he went he went to take receive the supply of the arms. These are something which are not authorized by the law. So it is an agreement. He's receiving the consignment of the arms. He's paying the amount which has been decided by between the two parties. So it is an agreement, but it is not a contract, because the laws in India don't permit these kind of acts. Now, wrapping up the concept of civil law, it basically is something which takes place between two private parties, two individuals. Now, individual is something like two persons. Now, again interpreting the concept of person as has been enshrined in law, is something that person covers a human being as well as a corporate body, as well as a statutory body. Statutory body, any body, any government body, basically in layman terms, like uh, like you can say public works department, like we have the electricity regulatory authorities. They are also the persons. If any person has grievances against these bodies, they can also be tracked before the court. Then we have corporate body as well, like we have Reliance, uh, we have JP, we have different types of banks, HDFC and Punjab National Bank and all. So these in law designates these as well, these entities as persons as well. So if anybody has grievances, or if these organizations or institution have grievances against any person, uh, they can approach the courts for the remedies. Then we have personal laws. Personal law is something which has been given a very dynamic approach by the legislative bodies of India. Here what happens is India, it is a nation with a diverse culture, diverse traditions, many people from different religions, from different castes, from different communities, from different backgrounds. All of them live together and are governed by their single constitution. But apart from the constitution, apart from the civil and criminal laws, there are something which is which they follow as their customary practice. Okay, so what Indian law does, Indian law recognizes these practices, which differs from religion to religion, caste to caste, and community to community. Indian law recognizes these also. So Indian law has permitted, and accordingly there are separate laws for each, which govern the affairs of each and every individual religion. So far it has been distincted on religious basis. Like we have Hindu Marriage Act, we have the Hindu Guardianship Act, uh, laws relating to the distribution of the title and property among different, like so basically in Hindus we cover the person who practice the Hindu faith, then the person who is a Sikh, then the person who is a Buddhist, as well as the person who is a Jain. Then we have a separate Muslim law. Muslim law covers those who are Parsis and those who are Jews. Then we have separate laws for Christians as well in India. Not above the constitution, but yes, just to recognize and just to respect their customary practice and just to respect their religious beliefs. uh, a space has been carved out, and accordingly laws have been made uh, for them, with for a limited number of affairs, or for a limited number of in a limited number of areas, which can be governed by their personal laws as well. A better example, nothing better example can be the one like the marriage taking place in different religions. Like in Hindu, there is the Sat Fera. Then there is they're applying this vermilion sindoor in the mang. Then we have this Kanyadan. So even the court, even if a Hindu goes and contends before the court that he has been married, or she has been married to that other person, and there has been the customary practice, these customary practices has been followed by which courts will very well recognize these. Again, in Muslim, there is the concept of this uh, co- quoting three times of kubule kubule, and then what so when a Muslim approaches before the, and there is there is the practice of donation of meher by the male part, by the groom part to the bride part. So if any, either the Muslim groom or the Muslim bride approaches the court and contends that they are legally wedded, as the customary practices and the meher has been followed and the meher has been donated by the groom party to the bride party, then it will be very well recognized as their legally wedded couple. And above all, we have the constitutional law, which is the supreme law, which is something which is above every law in India. This is as the one liner over here suggests, the overarching framework. Any law inconsistent with the constitution can be struck down with the court. The recent one that I can quote over here is the abrogation of Section 377 of the erstwhile Indian Penal Code, which abolished and which prohibited the marriage and the relationship between the persons of same sex. So now, what constitution has has interpreted with regards to Section 377, that it is straight away derogatory and it is straight away against the principles enshrined in the Constitution of India. So this due to as it was inconsistent with the principles of the Constitution, to be more precise, inconsistent with the right to life under Article 21 of life and liberty under Article 21 of India. So now today we don't have Section 377 in nine. It was scrapped down from Indian Penal Code. Now the recently enacted Bharatiya Nyaya Sanhita doesn't contain any provision which prohibits or criminalizes this same-sex marriage. So, constitutional laws, again, the principal feature of the that has been the greatest shield for each and every individual or each and every citizen of India, is the fundamental rights that is contained in Part 3 of the Constitution of India, starting from Article 12 and coming and concluding at Article 35A of the Constitution of India. Within the broad ambit of this fundamental rights, we have the right to the right to freedom of speech. We have the right to practice and profess and preach the religion of our choice. We have the right to constitutional remedies. This right to constitutional remedies I will be discussing in a bit more detail. Then we have the right to life and liberty, which again, if you see in the Constitution, it is a simple one-liner which goes like every individual in the nation has the right to life and liberty, unless otherwise lawfully prohibited, lawfully restricted by law. So basically, this simple one sentence in itself has been interpreted over the years in such a great length that a separate book can be written on this right to life, on this single title of right to life. Then we have the right to constitutional remedies, which is again a very strong weapon that has been granted to the individuals against the atrocities of the states. Under this, we have basically two articles under the Constitution of India. Those are Article 32 of the Constitution of India. Under this Article 32, if there has been any unreasonable, unwarranted breach of fundamental rights by any public authority, then the aggrieved person can approach the Supreme Court of India and can claim remedies and the restoration of their infringed fundamental rights. Then we have Article 226. in this article, the similar power has been conferred upon the high courts of different states. But yes, it is compared to Article 32, it is significantly broad in nature. Under Article 32, an aggrieved person can approach the Supreme Court only when there has been an infringement of his fundamental rights. But under Article 226, an individual can approach the High Court even if apart besides the infringement of his fundamental rights, he can approach the High Court even there has been an infringement of his legal rights or any other matter. That is the header of the court to decide whether this is sustainable or not. The person is at the liberty to approach the High Court for any matter, if he thinks that he has been if he has been subdued, and he has been subjected to inferiority by any public authority. And this is done by the means of 5 different kind of writs. Those are writs of habeas corpus, then mandamus, then we have certiorari, then quo warranto, and writs of prohibition. And then there are some landmark cases. Now, okay, so before discussing these cases, I would like to briefly quote and to put it to your knowledge that the sources of law, that the actual the like the initial points of law from where law flows. The general notion is that law basically flows from only the bills that are passed from the Lok Sabha, then from the Rajya Sabha, and that gets the assent of the President of India, and eventually enacted as the act and enforced by the executive authorities. But apart from the statutes designed by the parliament, there have been other sources of law. One of them, as discussed is the customs, as I have discussed earlier. Like customs is like something which is followed by any individual of a specific religion or caste or community since ages. It is also recognized by a law as a law. Then we have the precedents. Precedents is the term which is which refers to the landmark decisions given by the Supreme Court of India and the High Court. These two courts are basically the courts of record in India. So whatever decisions are given, whatever decisions are laid, and whatever guidelines are laid down by these courts, they are again treated as law in India. This we will be discussing in detail in this Vishaka case, which coming upon the cases, we have the Keswan and Bharti case, no doubt one of the most landmark case, and which is taught as an indispensable part of the law course in India. Each and every law school covers this case within their syllabus. So in this around more than 1,000 page judgment of the Supreme Court of India, so the one basic one principle and one of the remarkable findings of the Supreme Court was the concept of basic structure doctrine. Like basic structure doctrine is something like some parts of the Constitution, like fundamental rights and DPSPs. These cannot be amended, and these cannot be subjected to any kind of change. These needs to be as it is. And even if the courts have to interpret these provisions, they have to follow, they have to restrict themselves to a prescribed boundary line. Then we have the Maneka Gandhi case, which covers which covers a detailed interpretation of the Article 21, that is the right to life and liberty, which through interpretation of the Supreme Court again extended its ambit, and within that extended ambit covered the right to personal liberty within the ambit to right and life and liberty. And then we have the case of Vishakha. Vishakha case something is Vishakha judgment is titled in Bhavri Devi versus State of Rajasthan. It is the case which is somewhere very close to my heart, as I had the opportunity to research upon it and to present it before the Indian Law Institute. And in this when this case came before the Supreme Court of India, it was a case related to the workplace sexual harassment. There was a daily wage laborer who was a female, and she was exploited and gang raped in some countryside of Rajasthan, in a remote village area. So at that so now take Supreme Court, as per the laws for the punishment of rape, so punish the offenders. But coming to this, but what they pointed out is that there is an increased unlawful, unethical practice going on in the country in various workplace, be it private or public, that female employees there had been subjected to sexual harassment, unnecessary, unwanted, and unreasonable sexual remarks and sexual exploitation by their superior figures in the office. So, but unfortunately, we don't. The country was not having any law related. Country was not having any law related to to this menace of workplace sexual harassment. So for the time being, Supreme Court laid down the guidelines, which were around 25 to 30 numbers, and instructed every private and public workplace to strictly abide by these guidelines. And these guidelines, being the precedents being the part of the precedent laid down by the Supreme Court of India, so they were treated as a law. And then we have the Navtesh Singh Johar case, which I have discussed, which decriminalized consensual same-sex relations by striking down Section 377 IPC, only on the just on the ground that it is contrary to the Article 21 of the Constitution of India. Then so this was always the structure of the Indian legal system. Now coming to the significance as to why India's legal system matters. So before discussing the significance of Indian legal system, I would like you to just briefly imagine, just like tomorrow on 26th of July 2026, suppose there is no law in the country. Suppose the country is every single law that governs every single law in this country that governs various aspects, civil, criminal, has been abrogated, has been scrapped up. What will happen to the nation as a whole, and what will happen to the individuals? So even the imagination creates a sense of unrest in the mind of each and every individual. So that's why legal systems, that's why the laws have the significance, and that's why India has a dedicated legal system, and which very well understands that in legal system is like an oxygen, which we cannot see but which is necessary to the sustenance of life. As a human being, we cannot see oxygen. It is everywhere. On all the four corners. But and it is very indispensable to life. Similar is the concept of legal system. If for any nation it is like an oxygen. If it is not there, the nation will just go down into the state of unrest, anarchy, and this kind of deterioration. So in a crux, legal system, laws act as a guardian of rights. Every citizen, it is only law that provides them with the rights, and right to free speech, whatever there is a certain boundary line, but within that boundary line you are free to speak whatever you want to speak. You have the right to privacy, which was established by the Puttaswamy judgment. Again, this was against this un, unreasonable exercise of the autonomy by this BJP government, which came with the regulation that the the bank account and the mobile number shall be linked, and there will be a central server. So there will be a central server which to which each all the of 140 million 140 million people of the countries, they shall have their Aadhaar attached to it, and all their data will be accessible. So Justice Puttaswamy, who was the retired Chief Justice of the Karnataka High Court, he contested this. He contested this, and he challenged this before the Supreme Court of India, contending that it is straight away against the fundamental rights of of the fundamental right of life and liberty under the Article 21. Supreme Court interpreted this as that the right of privacy is an indispensable part of the right to life and liberty guaranteed under Article 21. By the virtue of which we have the right of privacy in every sphere. If we are in our homes, or we are using our mobile phone, which again contains the concept of digital privacy. So it is this credit goes to the legal system only, which is evolving as to catering to the various needs of the society. And then we have the law, which acts as the economic backbone. Today we are living in the age of globalization, where the commercialization has extended its arms beyond the national borders, and we are engaged in transactions with many countries. And within the country also, we have the transactions going on between different states, between different districts, with different persons now, and which again are principally regulated by the contract, which I have discussed in the previous slide. And then the property rights are there. Whenever you purchase a property, you have to go through a range of compliances. Whenever you sell a property, you have to go through a range of compliances. Even if you come up with any startup, even you are running a small business, or you are having a large scale business, there is a law which you have to abide by. Even, and this ranges from the very minimal economic transactions to very large scale economic activities taking place in the nation, right from the large scale manufacturing process going on by the Tata Group of Industries, to any simple small scale farmer taking loan from a cooperative bank. Each and every aspect is governed by the law. Then we have the federal balance, which again protects us from the rigidity of the union legislature. There has been a federal balance. There is a state legislature which has a fair amount of autonomy with regards to lawmaking and law enforcement in their own territories. Well, then we have the challenges. Yes, in a country like India, as we can see, every coin has a two sides. Everything has got the pros and the cons. Now, although we have more than 300 we have more than 300 or 500 statutes in the country. We have so many precedents laid down by Supreme Courts of India. We have personal laws, we have everything. Still we are lagging behind in the timely disposal of cases. The the reason can be attributed to a number of factors. As you can see the figure, this 50 million plus pending cases are there all across the nation. And one reason that has been highlighted over here is just we have 21 judges per million against the recommended benchmark of 50 judges. Now this is less than the half that of the figure recommended. Then we have the lack of legal awareness. Then we have the this like very like very this very distorted structure of the executive and the bureaucracy in the country. Then we have this rigid legal compliances. Then there are the malpractices, corruption going on in the country, and people not being aware of their rights. So these are the challenges that India's courts are facing as of now. And there is still we have a long way to go. We are here still as a developing nation. On the similar lines, India's judiciary and India's legal system is also in a developing stage. So, and another one is the collegium controversy, as I would like to discuss it over here. It is again, this is not something which is laid down in any statute, in any law book of the country, but which is something which has been practiced and which is still practiced in the Supreme Court since the independence of the nation in 1947. So basically in collegium there is a lobby of 5 senior most judges in Supreme Court. So which is again informally headed by the Chief Justice of India. And after the tenure of that presiding Chief Justice of India comes to the conclusion. So it is the collegium who decides on the basis of seniority, not on the basis of merit. It is decided on basis of seniority, that who is going to be the next Chief Justice of India. This is something which is not laid down by any law. This is not laid down, which is but it is something. It is kind of autonomy which is excessive autonomy or unreasonable autonomy which is being practiced since ages. And like it was challenged, and the government, the recent BJP government, after first time coming to power in 2014, it tried to abrogate, it tried to scrape out this system, and tried and came up with the setting up of National Judicial Appointments Commission. But again, it was challenged before the judicial authority itself. This is the design of the Indian legal system, in which if you have where we have the courts as the guardian of the law, judiciary acts as the guardian of the law. But what should be done if the guardian makes the mistakes, if guardian is on the wrong footing? So again, it was challenged before the courts. Where the courts, who were very rigid in their approach, they straight away struck down the National Judicial Appointment Commission concept, and quoting that it infringes the independence of judiciary, which is one of the essential features of a democratic nation. So it is being infringed by this National Judicial Appointments Commission. So this should be struck down. More informally, it was during Indira Gandhi's regime. Srimati Indira Gandhi tried to tried to override, tried to jump over the collegium practice and appoint the Chief Justice of India on the basis of merit, again quoting the independence of judiciary as an indispensable part of the constitution and one of the basic of the constitution and one of the basic tenets of a democratic setup. It was again abrogated. So the reforms and the efforts to curb these are still underway, and legal system is still under evolution, and it is something I believe that which is very dynamic in nature, and which cannot have a definite boundary line. And then we but yes, within that boundary line, steps can be taken to make it more efficient and to make it more approachable to, and which is still diligent efforts are being undertaken by the judiciary as well as by the legislature to make it more to make it more approachable by each and every individual, by even the last citizen of the nation. And the concept of ADR, that is alternative dispute resolution, is something which is one of the remarkable developments that have been taken place in the Indian legal system so far. Under this alternative dispute resolution, it basically, in a simple one-line sentence, it refers to the settlement of disputes outside the court. That you don't have to approach courts. Even the courts have even the courts back this concept, back this process significantly, and they themselves refers many of the pending cases, many of the matters, even before they are instituted in the courts. Courts recommend the parties to take the course of alternative dispute resolution and to settle it amicably. Alternative dispute resolution, we have under this alternative dispute resolution, we have the process of arbitration, and we have the process under which the parties have the autonomy to the extent that they can, through mutual consent, appoint the presiding member, that is called the arbitrator. In layman terms, the judge of that particular matter, of that particular dispute between the two, can be appointed by the parties through mutual consensus. Then we have the mediation. In the mediation, it is just like everyone of us must have seen that if there is any quarrel, if there is any quarrel, or any differences happen between two individuals in the society, in the locality, then there is a one sensible person who comes to the rescue, and he through negotiation and through settlement talks amicably settles the dispute. So this is basically what mediation is. Then we have the concept, then we have the process of lok adalat under this alternative dispute resolution. This alternative under this where under this there are like petty small matters, like we have the pending traffic challans, we have the outstanding loans. These matters, instead of dragging it to the courts and keep it lagging for a significantly longer period, better take it to the lok adalat, where it will be decided in a single go. And the process and the rigid and the technical processes that are applicable to the courts are like this alternative dispute resolution basically provides us escape route to all these to the nuances and technicalities involved in the adjudication of any dispute by a court. And then we have the legislative modernization, and under which law, yes, we have to the lawmakers they are accountable to the citizens. And yes, any law and any legislation that any bill that is floated before the parliament, be it any house, that is the Rajya Sabha or the Lok Sabha, a general uh, a general idea of the citizens is taken into account. What is their opinion is to be what is their opinion, their take, or the citizens take on this very bill, is be it adversarial or be it supportive, needs or uh, unbiasedly and indiscriminately, it need to be taken into account. So, in a brief, in the limited time that I have been given over here, this is the journey that started from the pre-Vedic age, and now it's 2026 running in the modern era. So this is how this is my take, and this is what I had to present on the evolution and structure and the significance of legal system in India. Uh, uh, Thank you. Thank you,
Thank you so
sir.
much, Dhruv, for such an interesting session. Like, I used to think that I know quite a bit about the Indian laws and the regulations, the systems, way our courts and the legislative has been laid out. But like listening to you now, I feel like I only have seen the tip of the iceberg, while the majority in its mammoth form remains hidden to my eyes. Because I
Well,
remember
I will tell you something,
reading
Kartikeya. I will
political
tell you
science only
something
till
very
class.
honest. Sorry to interrupt. So sorry to interrupt you.
Sure, sure, you please continue.
No, so there's one thing I would like to tell you. I guess Aditya Kashyap will agree with me on this. I'll be very frank and very honest on this. That even the best advocate, even the top ranked advocate of India, be it Sibbal or Manu Singhvi or Ramjet Malani, even he cannot say with certainty that he knows the law as a whole. Even he does not he does not know each and every law, each and every rules and regulation of the nation. That's what I say. No, it is
Sure,
very
you.
dynamic.
It is very large. Actually, I feel like that.
Mhm.
And thank you so much for such an informative session. Now I would like to open the question and answer session to all our guests and audience. If they have, if anybody from the audience has any questions, kindly ask over here, or you can connect with you directly also. So Shatadru da, Ritesh da, Vikas da, anybody.
Uh, this is more question on the detail. What's going on the, LGBTQ side of things? A few years back, as you also pointed out, some of, provisions or acts were decriminalized. But has there been any further work on that side to give more, freedom of choice and, legal status to same-sex relationship, etc.?
Well, legal status has been given to same-sex relationship. That was with this Navtesh Singh Johar case only, when section 377 of the IPC was decriminalized. But yes, if for any further development, for their better stuff, for to promote their better standing in the society, no concrete steps have been taken so far. Even one particular act is there in the one particular statute is there in the country. I would like to quote that particular statute. It is the Transgender Protection Act. Okay, so it was even before the decision of the Navtesh Singh Johar case was given by the Supreme Court of India. The act was in place. Now, tragically, the act lays down gives the legal status to transgenders. Gives them the equal status in the society. But with regards to the exploitation, that I'm quoting the ground reality, when every one of us might come across in India, come across there's in local these transgender people in local trains, on the traffic signals and other places, but they are the condition are still more or less the same. We don't include them within the employment. We don't mingle with them in the society. Okay, so uh, the notion, the belief of the people is like it's very orthodox, and as it used to be in the previous decades. So on the ground, in practicality, nothing much has changed apart from that, and apart from the fact that they have been given the legal status.
Thank you.
Most likely.
Hello.
Yes.
Yug. Yug, am I audible?
Yeah, I can hear you very clearly. No, your voice has gone.
Actually, right now we have all seen the protests that are going on at Jantar Mantar, and at a state level also in Patna recently. We faced a similar protest in Muzaffarpur, in my hometown also we faced a similar thing. So my question is there any law that makes the government, after being elected for the next 5 years, accountable to the people, and does law give power to its citizen that if
Where
they are not happy and they are not satisfied, the government is not working as per the expectations, can we change that? Can we take the power back while the 5 year term is going on?
So before I answer, I'm so sorry, where actually your voice broke down in between. So can you please come again, or if it is possible, you can just write it in the chat box somewhere.
Okay, sure, I'll come again on the question. My question is that we recently saw the protests at Jantar Mantar in Patna, in Muzaffarpur also 2 days back, I saw protests. So my question is that does law give its citizen the power to re-elect a government, to take a minister or a government down from their power during a 5 year term? Like right now that last year only in Bihar, we had an election. We chose the citizen of Bihar. We chose Nitish Kumar as our CM, but right now Samrat Chaudhary is our CM. And if a majority of people, if a majority of the citizens in Bihar are not satisfied with him, they are not okay with Samrat Chaudhary being the chief minister, or not quoting any particular name. But in case of any minister or any certain person being in power, and the citizen, the people of this country, the people in question are not happy with that, they are not okay with that, does give us the power to bring him down from that seat?
Well, see, I will start with the concept of universal adult franchise. Okay, so every person has the right to vote. They have the power. They have the authority to elect the people of their choice. Okay, but with regards to with regards to the removal of any sitting person from his office. Okay, like. I would skip the nominated ones. Not the select. I will skip the nominated ones like the IS and IPS. I would focus my answer on this elected peoples, MPs and MLAs. Okay, so no law by far has been made upon or with regards to the removal of any person from their office. It had there been any law, you wouldn't have been seen these violent protests all across the nation. All in as citizens of the democratic nations, all we can do is to make a peaceful protest, and to, like, if we are not and to publish our disagreement, okay, before the government. Okay, and then it is up to the government, and largely it is upon the government to take the actions, or you have to wait till the period of 5 years, that is when the elections happen, then you go and choose. So no express law is still there in force in India with regards to the removal of any person from his office.
Okay, thank you so much.
My pleasure.
Yeah, thanks you for taking out the time. Am I audible?
I'm more than grateful. I'm more than happy to take out time for this, and
Yeah, so by what I've heard throughout, it's really very promising to see one of our younger brothers uh, so well read, such a vast understanding, right? And I'm part of the Adda organizing committee. One of the objectives is also to for the junior batches, the ones who are studying right now, to
right,
understand more career opportunities. So I think this is going to be of immense help. People can see beyond engineering and medicine, which are by far the more popular professions that students choose. My discussion. I mean, I think it's a very big topic, but I just want to understand from you uh, that how do you feel is the independence? I mean, judiciary is of course considered one of the pillars of democracy, and we have seen how people have lost faith in maybe the other pillars of democracy. But somehow, I mean, I personally feel judiciary is held out. And from your conversation, it was very clear that they had been protective about who gets to choose who's the judge and everything, of what I could gather from the conversation. So, do you think that the judiciary will be? I mean, what's your feeling on this? I think you got the point I was trying to make.
right. I got it. So basically, the point is that as I had quoted in the presentation in the session, that judiciary acts as the guardian of the legal system in India. Okay, so that so that's why somewhere the legislature is making the laws. Okay, fine. The the executive, the bureaucrats are enforcing, implementing the laws nationwide, but it is judiciary who is responsible, and who is responsible and who has a considerable amount of public faith for deciding whether the laws that are being made and that are being implemented or enforced are right or not. So they are like on a, if you go by the constitution, or all on an equal footing, but yes, practically they are on a slightly upper pedestal, because they have to protect, they have to act as the shield. Okay, so for any person, for any entity who is acting as a shield, so it is like the faith of and it is, and also it is a last recourse. If you you lost from the you lost from the parliament, from the offices on the MPs and MLAs, you lost hope from the from the offices of the commissioners, SPs, DMs and all. Then then the judiciary, the courts are the last recourse. And that's why, and if it is not promising, and if it happens, if it proves to fall short of the responsibilities that has been conferred upon it, then obviously it will like malign, and it will like this you can say narrow down, that will like that will break down the strength of the legal system in India. There are many people I have come across who have disagreements with the judiciary as well. in a very simple term, they say that courts are fraud. Courts do nothing. They are very lethargic. They are very delayed process. Okay, in practicality, it is, and this is what something I highlighted in the session also. But again, uh, yes, there are challenges and there are loopholes which needs to be addressed. But by far, due to the role that has been conferred upon the judiciary, it is something which garners more faith of the citizens till date.
Thanks, you. Thanks.
So now I would like to thank you for his session, such an informative session to all of us. And I would also like to thank Aditya for his moderation and introducing you to us in such a interesting way that we all were here for the whole session. I would like to thank our audience. I would like to thank which helped us connect with you and Aditya on this special topic. And I would also like to thank Shatatruda for his question and the guidance that he has been providing to students from Vidyapeeth in his through his Adda sessions. Thank you so much. Thank you so much, everyone. And with this, I would like to end this session. Thank you so much. Bye.
Thank you.